of this. Again, guys, I just said there is a mic here.
I didn't see.
It's okay.
So for the conflict of laws, we've discussed that it's blatantly speaking irrelevant to the argument that we're making.
I'm talking,
'Cause-
what is this?
The structure of the argument.
What does it intent, complete derogation, other stuff talking about choosing law displacing CSG, non-contracting state?
Here we were looking into analyzing the intent of the parties according to Article 8 of the CISG and the different examples in the commentary that we could use to rely on our analysis.
And when we were discussing the intent of the parties, intent about what specifically? You have to turn it on.
To prove implicit exclusions.
Okay, so we were discussing how you can
Explicit or implicit?
Implicit.
implicit. Yeah. So we were discussing the last thing that we were discussing is how you can exclude the CSG. And we discussed that we start, with Article 6, which basically tells us that it should be an explicitly you should exclude the CSG, which means that the language should be, the law of Equatoriana excluding the CSG. That will be the explicit exclusion. But we also recognize that under the commentary, there is also a situation where implicit exclusion of the CISG is possible. And how do we get to this implicit exclusion is by looking at the intent of the parties. And these examples that we had that are, 1, 2, 3, 4 are basically an examples where the courts or tribunals have interpreted parties' intent to mean exclusion of the CISG, meaning when they would choose the law of non-contracting state, the courts, tribunals have determined that the intent of the parties was to exclude the CISG, okay? That was the implicit exclusion. They didn't say specifically excluding the CISG. Another example is if they would choose the law that is displacing the CISG, meaning they are choosing the law that solves the problems that the CISG is solving. So why would we rely on the CISG? Then we had other stuff talked about. I think here the point was that the contract included the provisions that do not fall within the scope of the CISG. And then also complete derogation. Again, contract is as detailed as possible, so there's no need to rely on the law, which means that respondent here has to use the facts of the case to show the intent of the parties was to exclude the CSG. Do we have in our scenario, in a problem here, any of these examples that the commentary has given you as an example?
Just briefly before we get to that, I want to ask, in the CISG, when we're trying to determine the intent of the parties, what is the standard that applies when determining the intent of the parties?
Looking at the CISG, we can look at the parties' conduct, statements, and the relevant circumstances of the case.
So that's all the evidence we can use, right? But what's the standard that we're trying to determine to know we have party intent?
There has to be a clear manifestation.
Is that in the CISG?
Yeah, under Article 8.
Can you show me?
Right now?
Yes.
Of course, right now. Where in Article 8 does it say the manifest clear intent?
It's under commentaries.
Under commentary.
Yeah,
We
under
just
Article
it's in
8.
the CISG and now it's in the commentary.
Yeah. So
Decision.
Commentaries on Article 8, I'm sorry.
go ahead.
It's an Untitled Digest and then opinion number 16 of Advisory Council.
Does it say why? Where manifest clear intent comes from? Do you know where that comes from? Over here. It takes a sec after you turn it on.
To determine the intention of the parties, we should consider the reasonable person standards, which are under Article 8.2, and then under Article 8.3, or relevant circumstances.
So if you were looking at the CISG alone, and we didn't have the CISG Advisory Council opinion, if you looked at Article 6, it says you can derogate or fully exclude all the provisions of the CISG. And the parties would do that by their actions or their intent, right? And we looked at the CISG to determine party intent in Article 8, which deals with the subjective intent, Article 8.1, or the reasonable person when trying to determine the intent of the parties based on their communications or statements, right? So why is the standard manifest clear intent? This is something you should know because as we talked about before, when we're talking about burdens and we're talking about standards of persuasion, this is a very unfavorable standard for the respondent to meet. Don't take it for granted. The CISG doesn't say manifest intent. Someone have a microphone over here?
It should be clear intent because Article 8.1 states that the other party should have known of that intent or could not have been unaware.
Right, but doesn't Article 8.2 says where Article 8.1 is not met? Right? There's
Yeah.
still a way to get to the intent of the parties, which is the reasonable person in the other position, right? So when we're trying to develop a rule, remember, y'all are lawyers. You're not just passively reading what other people have written. Your job is to develop rules for the tribunal to reach conclusions and write an award in your favor. As we talked about before, we're not claimant anymore, right? We're happy. Manifest clear intent, that's awesome. That's super hard, right? That's a super high standard. It's basically something like Article 8.1. It's a really high standard to meet. But if you're a respondent, manifest clear intent, show me. Show me where in the CISG is what it says. That's not the standard. The standard for the CISG is going to be in Article 8.1 or Article 8.2, right? I don't know if the support for the manifest clear intent is something that's impossible to get away from, but neither do you, right? As respondent, your job is to interrogate that standard and find out the nature of that standard, why it's so high and different for the purposes of choosing the choice of law, but only the choice of law of the CISG, right? If the CISG is trying to interpret whether they've chosen, for example, the law of procurement, as they do for in the RFQ, is the standard manifest clear intent to exclude certain laws in that circumstance? No, right? You can derogate from each provision of the CISG one by one, but none of those have to be manifest clear intent under Article 6, right? That derogation just exists in the contract. That's perfectly fine, right? Why can't we do that? Why is it different for the exclusion? Know why, and figure out if you can interrogate that standard and realize it might be different. So I just want to not let you take that for granted. Read that advisory council opinion. When they cite the cases, go read those cases and see what they say. You'll find commentary that is probably against that CISG advisory council opinion. It's not going to be written by the most fancy people, but those most fancy people are specifically here to make the CISG as applicable as possible. That's part of their mission, right? Find those who are not in that same approach so you can articulate that approach and interrogate and challenge the given wisdom of manifest clear intent if you can. Lowering that standard would be a very persuasive argument. Understood? Okay. We were talking about your examples now. I just wanted to get that first. Any questions on that? I feel like I kind of shocked everybody just now. That's important. That's important.
So my question was, what do we have any factual information in the problem that would fall within those examples that we have found in a commentary? Where is the mic?
A factual example we have is in the PSA where they have chose Equatorian law instead of having the applicable law be the CISG. So the second example here.
Choose a law displacing the CISG. Does the Equatorianian contract law displaces the CISG? Why not? Yeah.
Equatoriana is a contracting state to CISG. Therefore, mere choice of Equatorianian law does not necessarily exclude CISG.
So it would definitely not be they have not chosen the non-contracting state. They have chosen it. But the law of the, you want to, yes?
Well, there can be like clear intent about choosing the law displacing CISG because the parties knew about the model contract, and that's it says like the CISG is applicable or the other questions are are regulated by the law of Equatoriana and the domestic law. I can refer.
Yeah. I was about to ask you, referring to the problem.
While he's doing that, is there like what is the paradigm classic example of a law displacing the CISG? I mean,
Well, in our case, it would be if they specified Equatorian Civil Code, that would have displaced the CISG.
right. So it's still Equatorial law, but they were specific as to the nature of which code applies versus picking the body of law of the country, which of course includes the CISG. So that's how that displacement would occur. And again, as we keep doing all of this, because respondents got the burden here, and when you're as the respondent, you should be eager to address this question because you get to be super creative. And even though you have a difficult argument to make, that's where you can really shine for the arbitrators. Show them your research, show them that things should not be taken for granted. Yes, there are these paradigm examples, but not always are the paradigms the one that work in every given situation. And here, there is still that manifest intent as evidenced by these things, right? Or that manifest intent may not be the standard. See what I'm saying? Be able to interrogate those things and show that work.
So, for example, we have determined that, okay, we have not chosen the non-contracting state. We have not chosen the law displacing the CISG. So we didn't specify Equatorian civil contract law or something like that. Other staff talked about in a contract that would suggest that the CISG is not applicable. Do we have that?
Yes, we have in the claimant exhibit C2, page 9 of the problem. I'm sorry. Page 12 of the problem, article 28, the termination of the right to terminate the contract for convenience. It's not mentioned in the CISG that this kind of right exists, so there is no derogation. It's like pointing out that they knew about CISG was not applicable. So they were
okay. That's one of the arguments that we could try to make. How do you feel as a group about that? Do you think it's a strong one?
Does anyone not understand that argument? Oh, go ahead.
I think if we were to argue that on its own, it would be weak. But if you combine it with the fact that they say fundamental non-performance, and in Respondent Exhibit 3, page 32, Ms. Smith, I think, yeah, she discusses assurances and misrepresentations under the law of Equatoriana. So I think when you pick up bits and pieces throughout the record, you can kind of make it a good point.
Yeah.
Okay.
What about the assurances and misrepresentations point? How do we feel about that one? Do you all know what she's talking about?
So, page 32.
I think she's talking about how they can tell respondent in a very positive light that their negotiations are going well. So how they can not misrepresent it in case it goes bad.
Does the CISG apply to misrepresentation? Is that the law applicable to determine misrepresentation? No, right? So for the claimant, that's probably pretty bad because you're talking about domestic law. However, a sophisticated arbitrator would say this doesn't apply to us at all, right? Because it's not the contract law that deals with that. It's the law outside of the sales convention. So they're not necessarily displacing or addressing the sales convention really at all, even if they are dealing with the domestic Equatoriana law, which would definitely apply to those questions. So it feels persuasive, but we have to make sure we put it in the proper context, right? Understand what's being addressed there. Do you have something? Okay.
Anyone else has something to add?
For manifest clear intent? Yeah, go ahead.
Yeah.
Going back to the R3, does it affect the respondent if we know that claimant is trying to exclude R3 from the whole case? Isn't it one of the procedures trying to say that claimant is trying to say C7 should be included, R3 should be excluded, and respondent is arguing C7 should be excluded, R3 included. So those two are sort of shaky exhibitions. So relying on them to build our argument as respondent.
But actually it can help you because you can say, you see, it's so important, it's so relevant and material for our case to include our R3 exhibit.
Okay. Thank you.
Same thing with the C7, you know.
You also have to remember, in
Yeah.
particular with the without privilege offer, I think right now students are misunderstanding how that privilege protects, right? So the without prejudice offer, there may be a privilege for this without privilege offer, presuming the right kinds of laws and situations apply, but it doesn't apply to all circumstances, right? You might be able to redact certain things for the purposes of avoiding violating that privilege, but other components might be available as evidence. So, for example, traditionally, settlement negotiations or these without privilege kind of offers are privileged from admissibility into evidence because they can't be used for the purposes of demonstrating what the parties were willing to settle for, right? But the reason why, again, thinking about policy, why would that be the rule? Why would it be that settlement negotiations and settlement offers aren't admissible in adversarial proceedings? Anybody have an idea?
Essentially, it is that, again, lack of better word, but they're embarrassed of the offer that they've put forth in the current negotiations, and they don't want it to be used against them.
Mhm.
Whether it makes the company look bad or it's something that they would not settle for right now.
What's the effect of that? Like if you're policymakers and you're writing rules, what do you encourage by privileging those kinds of communications from admissibility in adversarial proceedings? Anybody?
It would bias the tribunal. Bias.
Yes, right? But what is it biasing towards? What is it that's being protected? What is the thing that you're encouraging by protecting against that admissibility?
You don't want to dissuade people from being able to discuss a certain factor.
Yes, you encourage settlement. We want to encourage settlement. Doing full-blown adversarial proceedings are not the way to do everything. If parties can resolve their dispute between them, you want to encourage that. You will discourage honesty and the ability to take on some losses at your own behest if that can then be used against you in a later adversarial proceedings, which is why these kinds of offers are generally considered privileged, at least in common law countries, right? But if that offer is meant to be shown that a fraud was committed, or that evidence is meant to be shown that for other purposes, right? That they knew the CISG doesn't apply, or other purposes outside of the thing that they're trying to privilege, for example, that settlement offer, you can redact that settlement offer and still put in the email as evidence to show, look, they know the CISG applies, right? You can't hide other information by virtue of privileging that component. So it's important to know if your teammates haven't thought through the use of that evidence for that purpose, you need to work with them because you might really want to use it anyway. And as your argument, you need to make sure you're consistent with your teammate.
Question about the explicit removal of any reference to the CISG, the updated model contract. So what if the arbitrator is like, but it's a model contract. Is anyone required to use this contract? Why is this relevant?
So I think for the respondent, it's a requirement. They're a state-owned entity, and it's a model contract they have developed on. That's my understanding of the facts.
And this is common in construction.
Yes.
So if you work with a state, they have commissions that develop model contracts that are publicly appointed commissions. And these contracts are super complex, which is why they make them standard forms. They also set things like specifications for how hard concrete's supposed to be and how wide beams are supposed to be. They're super, super comprehensive, these kinds of specifications and contracts. I think it's possible still, again, trying to interrogate our standards. Your question, I think, is relevant to that. Does the intent seem to be quite so manifest and clear in the context of a state-produced standard form contract that's used all over the state? Yes, in this context, it was used with a little bit more of a foreign party, but they are clearly trying to apply their own domestic law to domestic infrastructure projects. That's how they would do that. They would never dream of applying an international convention to the domestic production of an infrastructure project, right? Does that inform their intent? Are you able to interrogate that intent and say, they have these contracts out there all over the place. And if you are to make this decision, you're going to be, in effect, showing us that there is a risk that all of these contracts might be subject to international law, and we're going to have to go out there and renegotiate all of these contracts, right? That's one of the reasons why mediation is probably good for the respondent. You might be able to mediate that issue and decide to reform that particular contract provision and decide for sure this law applies and not other laws, right? So think about, this is what I mean by know who you are, right? When you're doing this kind of intent and trying to understand the intent, does who you are affect presumptions about your intent, right? Would you presume doing business with the United States that we'd be happy to apply international conventions? Totally not. We want our law to apply because we're pretty elitist about that. You know, we want New York law to apply. We don't want something else, right? And that makes sense. If you're in the UAE, you think they want to apply international law to all these construction projects, they want to apply domestic law, right? And I think everyone understands that. There might be ways to interrogate that standard based on that to figure out what you want.
So I have scrolled a little bit, so the focus is on the Article 8.3. Okay, so it says in determining the intent of the party or the understanding a reasonable person would have had, due consideration is to be given to all relevant circumstances of the case, including negotiation, any practices which the parties have established between themselves, usages, and any subsequent conduct of the parties. So in our record, in a problem, we have a lot of information that would fall within this, you know. We have a lot of information about the negotiation. We have a lot of information for the claimant, for example, maybe usages, they're saying the CHG is the golden standard for this kind of contracts from the claimant point of perspective. Do we have any established practices between the parties? No, but what do we have in information about the claimant? They have what? Yes. It's okay.
2 previous contracts, government contracts, where they use CISG.
Where they use the CISG. Okay, that's a good point for the claimant. But for the respondent, what is the good point? How would you, contradict them on that? What would you point? Or sorry.
What we would say is that those were based on the old model contract before the change in the model law clause.
Was claimant aware of the change of the model?
Yes, they were.
Is it yes or?
Yes, they were aware of the change.
Okay, that's what we're going to argue as a respondent. But is it truly that they were aware of it fully? It was what? What does the record say? Yeah, just a second. Just for him to answer, and then you can ask the question.
Claimant is in the position that he couldn't have been unaware about the change because it was officially released via press release, and claimant actually mentions it. In
claimant mentions it.
Yes. No. Respondent mentions it. I'm just mixing up everything. Yeah.
It's okay.
Yeah, thank you.
There is a point. They want to make some point here also. Anyone wants to add something?
Page 53 of PO2, paragraph 11 states that Mr. Law had taken a look at the model contract and the changes made to the old model contract. So clearly he was aware of the changes made. The head of legal or ex-head of legal of claimant.
Mm-hmm. Okay, you had a question? Can you give him the microphone? Mm-hmm. Is that working?
Okay. I have 2 questions for you. And the first question is that, is it possible to argue under Article 8.3 under CISG, specifically any practices which has been, which the parties have established between themselves? Is there any contradiction within these parts of article and the entire clause between the parties in the contract?
Well, I think there's different parts here, right? So Article 8, 9, and 7 as well are the interpretive clauses that you're using, right? These are how you use to interpret what's applicable to the contract and the intent of the parties. Article 8.3 just tells you the universe of evidence that you can use to determine intent, right? It doesn't create a standard, but it says this type of evidence can be used in determining the intent of a party.
And by
Right.
the way, it says including the negotiation. It doesn't say only this kind of things.
Mhm.
So other things can be taken into account. These are just examples.
But if you want to apply a usage, a international standard, industry practice, or a past practice between the parties, that's Article 9. And it says that those things are applicable to the parties, but you have to actually develop the standard, right? Don't take for granted that you say usages or international practice is applicable to the parties. You have to actually develop how they become part of the contract and demonstrate that there are international standards available. There might be international standards about the applicability of domestic law in these kinds of contracts. I'm not sure. As you do your research, remember to be focusing on construction contracts if you can help it. Find construction disputes if you can do it. Learn-
Especially as a respondent. Okay? And especially, I think the focus here it ties to your issue C, because you want to say it's not the typical sales of goods contract. It's a mixed contract for so many reasons, and there is not just the tangible goods that are selling. We are having an issue that it's not just the tangible goods, and then we also have services and the goods being provided and sold. So all of that ties into when we are going to look at what we're going to try to establish is the standard, industry standard, because realistically we do not have usage between the parties. Okay, this is their first time they're doing any kind of negotiations and any kind of business relationship. The fact that they have experience with other companies within Equatoriana does not establish a usage between respondent and the claimant. So I think there is something.
Yeah, and if you want to do the international practice, you have to read specifically the elements of Article 9. Are y'all able to see this?
Should we scroll maybe?
Yeah, I don't. Oh, yeah, scroll. Can I do it like this? Oh,
No, on the.
use a mouse like a nerd. Okay. All right. What are the elements? So Article 1 says are bound by usages, right? The classical usage is the one that I use all the time is 2x4. So in the United States, a 2x4 is a piece of lumber that's 2 inches by 4 inches. It's a classic, very standard piece of lumber that people use all the time. The thing is, it's not 2 inches by 4 inches. It's 1 3/4 inches by 3 3/4 inches. That's actually what a 2x4 is. So if you had a contract for the sale of goods that said I want 2 million cubic feet of 2x4s, and you got them to your warehouse and they were 1 3/4 inches by 3 3/4 inches, you can't sue them for nonconformity because everybody knows in the industry and the usages in this industry that a 2x4 means 1 3/4 inches by 3 3/4 inches. That's not an enforceable obligation. But here, Article 9(2) is talking about something else, right? Things that are widely known and applicable to their contract. Who can tell me the elements of Article 9? You can read and walk through it if you can see it. Anybody?
I have another question.
Good.
I'm from civil law country, and I don't know the meaning of without prejudice offer. Would it be possible to explain it in more details?
You should go to the procedural room.
Yeah, we'll do that in procedure room.
That's fine.
Yeah.
Yeah,
Yeah.
I participated there,
Yeah.
but it seems to me that you were talking about the without prejudice offer. That's why I
Yeah, I mean,
asked about
it just means I'm what we usually say is we're like reserving rights, right? So I'm saying I'm making I want you to do this contract with a 15% price reduction, but I make this offer without prejudice, meaning you cannot use this to prejudice me in a later
You cannot
negotiation.
hold it against me.
Right. You're trying to announce that you're making a settlement offer.
And
Okay, who wants to do these elements in Article 9? Somebody else. Do I see a hand? Anybody? What are the elements in Article 9(2)? Not you. You put your hand down. Somebody. You get right in front of you. We just go, I want you to say them out loud as you see them.
Yeah.
There we go. Yeah. Right here.
Thank you for volunteering.
Essentially, it's between the parties and what usages or like customs that they've made repetitive, I suppose. This is something that is a custom between them. No,
I'm making a face because we should not use the.
custom word. Yeah. Can't think of a.
No, it says to you usage.
Yeah, and
Usage,
Usage,
okay.
that's what it says. Yeah.
Okay, so
It's a good thing that you are associating with the custom because it helps you, have it in mind what it is, but it is a usage. Okay.
Yeah. So
which the parties knew.
yeah, it knew or ought to have known, and something that's widely recognized within the trade. So if it's something in construction, all the construction companies are
So
aware.
a couple things, right, where each
Yeah.
element matters, right?
Sorry.
So first, they're impliedly making something applicable to their contract, right? We were talking about implied intent before, like implicit exclusion. So we're in that same universe, right? It's not clear intent, but so they impliedly make something enforceable in their contract, or its formation, a usage of which the parties knew or ought to have known. This is kind of interesting, right? Isn't it interesting that the parties don't even have to agree on something, but they can actually sue on the basis of this term that isn't in their contract, right? That's why the standard is quite high. They must have known or ought to have known that that's the standard. That's an Article 8.1 standard, right? That's not a reasonable person. That's an Article 8.1. They must have known that that was the case, right? So, and what was the next part after that?
Something which is like known within the international trade community that they're in.
Right. So there's two things that have to happen. They have to have known or ought to have known, and which in international trade is widely known, right? So let's say in the problem, it said in all the domestic contracts in Equatoriana, they have uniformly said that Equatoriana law applies and not the international conventions, right? Let's say there was case law that said exactly that. It wouldn't work here because these are not in international trade, right? They have to be widely known in international trade in order for them to be applicable to the party's contract. What's next?
So something that's regularly observed by parties and people who are within the field.
You have to be in trade,
Yeah.
right?
So I don't know if any one of you were doing a Bismuth a few years ago
I
or
think
no last
last
year.
year.
Last year we had an issue of the like a cyber attack, and was there an obligation of one party to inform another about the cyber attack? And basically what we had to rely on was this Article 9.2, that it has become sort of a usage that the parties knew or ought to have known, that has been applied internationally within this industry of automatic vehicles, electrical,
Yeah. We had
whatever.
a student who, for example, went and found banking publications about the automotive, I think it might even be an automotive sensor industry,
Yes.
that said that the best practices that are uniformly recognized by the biggest player in the international automotive sensor industry, which is what the goods were, are these things. And they were able to say that based on the parties knew or ought to have known because they're a big sophisticated player and their banks are the ones who make them do this, and it's widely in which in international trade is widely known, which is exactly the industries that those publications used, and is regularly observed by being all parties practice it, parties to contracts of this type in this industry, right? So that was a really powerful argument in order to establish this international practice. It's actually quite hard to do that, right? But as we talked about this morning, the facts that are available to you are also those that are publicly available and true. So if you can find, and there's going to be lots and lots and lots of articles in the construction industry about like their dispute clauses and applicable law clauses, recommendations, standard form contracts, interpretations of those contracts, you can find a lot of publicly available information that might be helpful
Yeah,
to you
and
to establish the
what
use.
Robbie said, it's a really high standard, but it is a high for a reason, because if you have met it, it means it impliedly made applicable. Like you don't have to choose it. It's just, you don't have to expressly say this will apply. That's why the standard is high. And that's why when you're going to look for maybe, usage of something that is international known, you really have to make sure that you're finding companies and examples relevant to this specific industry. And what is the specific industry we have? Is it construction? It is a little bit of construction, but it's also hydrogen, ammonia. Okay, so it's a specific renewable, sustainable, green energy construction. So it's all of that. Okay, so I feel like there is sufficient information outside in the world. I sounded like X-Files.
You did? Oh, there's something out there. There's aliens. They're there. Bigfoot.
Yeah, there's
I've
something
seen-
out there, but just you have to dig deep. And by the way, it's not like you're gonna, like Abigail, I think she was the one who found that. Like
Yeah.
that was like really specific where you found it. Like it says, this is like the standard. But
By the way, what she did, is my understanding, she emailed banks and like asked for stuff. You can totally do that, right? If you see professionals who work in green energy, send them an email.
yeah, like what is the standard? Like what kind of type of contract and what is the law applicable?
Yeah.
There is something to this that the claimant itself, it's a golden standard. Okay. But when you think of why did they say it's a golden standard when this is like the really important project for them because they finally have to have, example of their technology to be applicable? Do they truly have a lot of contracts?
They're trying to make Moody's look bad. That's why. No, it was the Moody who said that.
Yeah. So it was the Moody who said that?
Yeah,
It's a
I think
golden
so, right?
standard.
And the problem is the Moody.
No,
the gold standard. Oh, fine, never mind. He wasn't a Moody, so he would have known. He shouldn't have known. You've lost your mic. Oh yeah, I think they're all dying. Maybe they just haven't charged them.
So I think it is. Oh. This was like a mic drop without me doing a mic drop. I think it is interesting. They said it's a golden standard because when you look at, their business practice and do they have a lot of experience? No. So why they're saying that? So maybe it is truly a standard for the industry they're trying to be a part of, okay?
I wanted to see, did anybody come up with an answer to the question we asked at the beginning? Why does Respondent want the domestic law to apply? Or like, what's the difference? How do we get out of the fact that they contracted away from that termination provision? Did anybody think about that and get an answer? You did? Great.
They're trying to terminate for convenience, and the threshold for termination in their contract is higher than the one provided by CISG.
Right, but they did contract for that provision, right? They specifically, the parties knew the termination for convenience was available in the domestic law, and they specifically contracted out of that ability to do so. So even if the domestic law applies, why would they be able to terminate for convenience? Have we figured out how they can do that? Do we know?
What would be your focus? Yes.
Is that the change in the government? So a drastic change that happened, which is why, well, I guess not, which
Sorry,
is why they can
I
terminate.
did this. I don't think it's that.
Yeah.
Even if they terminate the right under the contract law of the Equatoriana, they have the right to terminate it because of the change in the policy under the civil code.
Parties have the right to contract and contract out of the standard rules in even the Equatoriana Civil Code, which we have available as principles.
Unless.
Yeah, unless what? You know.
Yes, huh? Okay. I believe that respondents will probably seek to announce that provision void because it was based on misrepresentation, and he's actually setting the ground for that.
Right, but that would be a pretty perverse thing to be allowed to do, right? You should look at the Equatoriana Civil Code, the UNIDOR principles, and see if parties can do things that are expressly in bad faith. Right, because that would absolutely expressly be in bad faith. You know that your domestic contract provision, your termination provision, is enforceable no matter what we do, but they extracted 5% of the cost away from us in order to negotiate that termination provision. Right, that would expressly be in bad faith. And can they rely on that in bad faith to still terminate under the law? Right.
Okay, that's an interesting point, but I think you were trying to make a point that it was the claimant who was misrepresenting itself throughout the contract negotiation, and because of that.
Wait, how were they misrepresenting? I missed that part.
They said that they would meet, I think, 45% of local content, but they weren't able to do so.
Oh yes, but that's different than breach, right? That's different than saying what happened for the negotiation of this termination provision. Sort of like one breach doesn't justify a bad faith action, right? That might be a breach of contract, and whether it's misrepresentation is also different, but that doesn't mean that the termination provision is then enforceable, even though it was specifically negotiated in bad faith, right? How would we still need that to be enforceable? How would that work? Because again, I get to clarify what I'm asking here is under the CISG, it certainly would be the termination provision would still be applicable, right? No questions. Unless somehow Equatorial's domestic law would override that provision, but the CISG has certain principles that would prevent you from relying on those kinds of things, where you might be able to get out of it. If you're in the domestic law, how do we, it's still possible under the union law principles to contract out of a lot of those provisions and make your own contract provisions, including maybe this one. How would we be able to not do that and still be able to use it?
It's because in the Equatoriana domestic law, there's an exception for government entities to be able to opt out.
Does it always apply? It says always, right? Something like that. The state-owned entity can always terminate for convenience on the basis of a change in public policy. So maybe it's always overriding, and sure enough, they just negotiated that in bad faith, and we'll be all right.
Do you know overriding mandatory rules and that term? It would mean basically what? Teacher's mode, like I want that.
So in the PO2, let me refer to that.
PO2.
PO2, the questions and answers. The page. Just a second. Page 55 of PO2, paragraph 33. It says slight majority concerning it to be not mandatory. Like,
But interestingly, it's a slight majority, right? It's not universal. So I think you'd have to demonstrate this to the tribunal in a way that's persuasive and doesn't make you seem like you're acting in bad faith, right? But when they ask you, why does it matter that the CISG doesn't apply? You can say, because in our domestic law, we have a right that's available to us to terminate these contracts, and it's unclear what the case law is. Yes, but we want to. This is the law that applies to us, and we can fight on those grounds. That's where you want to live.
Yeah.
Right.
And Robbie, you're so right, because it's so interesting how they say for this one, like a slight majority considering to be non-mandatory. It is, however, largely accepted that the provision does not form part of the ordre public of Equatoriana. So it cannot be like a public policy argument, okay?
Right. It's not in violation of public policy to negotiate that provision. It's not an invalid provision, for sure. The question is, can they still do it even if they have that provision that's not invalid and contrary to that law? And apparently half of people say yes, or just above half. So Equatoriana is betting the house on that slightly greater than half to be able to terminate, right? But we have to think about their interest too, when we're talking about like in the mediation. They don't necessarily want to terminate. They just want to get a much better deal. It's got real Trump vibes to me. I mean, it feels like that right now. But like he's just saying, cancel all government contracts, cancel and destroy the USAID, for example, and then, or I'm going to impose tariffs on you to make you do something, and then pull them back immediately. He doesn't want the tariffs. He wants the deal that comes as a result, right? That kind of is what this feels like. And if they lose on the availability of that termination, suddenly claimant is in a great position. They are able to, it's much easier for them to argue that you can't terminate. You can only have terminate here. That termination that you did is invalid. Therefore, you have breached the contract. And now I get to have damages, which would probably include the price at 0%. They wouldn't get profit, but they get to go home and they get to keep their cash or whatever, right? So they're in a much better negotiating position if the CISG applies versus if the domestic Equatoriana law applies, right? The problem is when you tell the tribunal that, it feels a little bit craven, right? So you need to be able to understand at least how that works. And then when the tribunal asks you, which you will get asked this week, why does it matter whether the CSG applies? You got to be able to let them know the consequences and the difference in the applicable law and what remedies would be available. And that's why it matters, right? In a way that isn't a long-winded, circuitous, confusing way like I just did.
I do want to go back to your point because I think it was something that we mentioned yesterday a little bit. It's under the UniDraw principles, the fact that if maybe respondent can prove we have agreed on this deviation from our like a rule that will allow us to terminate convenience in all of it is dynamic. um, yeah, it's red now. Sorry. So we are saying, okay, we have accepted this. Yeah, we did get 5% off, but we have put ourselves in a position where we cannot terminate for convenience. But we did that because the contract that we thought we are getting is this, you know. So maybe there is something. I'm not buying it yet, as of yet, but doesn't mean that it's not an argument worth maybe exploring and being better in connecting and explaining, because I think there is some provision in UniDraw principles that says basically you cannot rely on something if you use them like misrepresentation and fraud. And basically, if you negotiated a contract knowing you're misrepresenting or using a fraud, basically that will not be acceptable. But I'm not 100% sure myself. And if you want to use that argument, you need to be ready to fully walk the tribunal through it and explain in a good way. Okay.
Do we want to maybe work on a roadmap and sort of show them how we do it?
I do want to discuss a little bit the fact that we immediately went to the implicit exclusion. Okay. We have not at all discussed the language of the Article 28. And the fact that we have chosen to exclude the choice of law, conflict of law principles or rules. What does this say? Principles, okay? Nobody has argument that this is helps us with to show that they wanted to exclude the CSG. Yes. Should we give them to charge those?
I just want to go back on the termination for convenience aspect.
But I'm sorry.
So we know that under CISG and UNIDWA, you can terminate for cause, but nowhere under both does it mention for convenience. We only have the ECC that says that governments can do that, but how do we approach the waiver of termination for convenience? What law is it governed by?
This is what we're talking about, right? How is it that they can contract to get rid of that termination for convenience right and still terminate for convenience? How is that possible? Because if not, there's no difference in the applicable law problem. There's no difference, right? You need there to be a difference. So you need to figure out how you can use that. And it might just be there's a 50+1% chance that you will be able to use it, and that's what you're relying on, right? That won't make you the darling of the tribunal, but sometimes you're not the darling of the tribunal. But you need to figure out what the answer is. If you don't know the answer, then what are we talking about? Like, who cares? What are we talking about? If we can't do that, we got to do the contract. You know what I'm saying?
So the reason why I want to discuss Article 28 of the contract, because it is the provision that the respondent has included in their model law contracts, okay? And they have included that when they made a change that they don't want the CSG to apply. I mean, I assume that the respondent, even in the government, has good lawyers who have at least tried to read Article 6 and a commentary to it. Why they have, instead of saying explicit exclusion of the CISG, why did they choose this kind of language? There had to be some reason behind it, okay? Does anyone have an idea? Did you at all, try to research this? Can we, exclude the CISG by saying exclusion of the conflict of law principles?
Can anyone tell me what that model contract, what is it like? What's the title of it? What is it? What kind of model contract is it? Because we know it's a model contract that we're using here, but is it a model contract for like building of circuses, or is it a model contract in construction industry? Is it a model contract for the sale of goods? Yeah.
It's a model contract for the purchase of goods and services by Equatorian state entities.
Oh, that makes it much worse for respondent, right? Because it's for goods and services. So when they're drafting the model contract and they're thinking about the purchase of goods and services, they could have said excluding the CISG when they're writing their contract clause.
It seems like such a silly, stupid mistake that it's costing them, in this case, a lot of money and time. But then in every other contract they will enter into, if the other side thinks, oh, you know, the CSG should be applicable. Or if the requirements under Article 11A lead us to the application of the CISG. So why did they choose this kind of language? Anyone believe that saying exclude conflict of law principles would lead to the exclusion of the CISG? We have a hand here.
I'll be devil's advocate. So
Be respondent. Be respondent.
yes, we know that they changed the model contract to strengthen Equatorian law power and the place for dispute resolution. So when they excluded conflict of law, they also excluded other jurisdictions' laws applying. So their goal was just to exclude CISG, but exclude everything else other than Equatorian law.
Okay.
And they just tried to use conflict of laws as a terminology that includes everything, basically.
Okay. We will need to, a really good point, but I feel like we need to back it up with something. So what would be the focus here? Why would this include the CISG? Because we also know once you ratify the CISG becomes a part of your.
So conflict of laws principle refers to private international law, which usually also includes CISG. So it can allude to something like intending to exclude CISG.
I agree with you that it can allude. What I'm saying that you have to have then good sources. You know, probably it's not going to be the big names, okay? And it doesn't always have to be big names.
Maybe Zlatan, for example.
Zlatan Meshkic could be a good source for it. He has built his reputation. So something to think about it. I'm myself not sure, nor I'm convinced as of it now yet. There is that I'm just.
So let's say the conflict of laws principles does exclude the CISG. What would be the mechanism? How would that happen? Somebody? The microphone? No?
This one is not working so good.
Yeah, just I'll restate your question. You can just, okay, yeah.
The exclusion of conflict of law principles might exclude Article 1, which can be considered as a conflict rule.
Why?
Because it leads to the application of what law is applicable when there are multiple potential laws that are applicable.
Right? It's some rule. It's not a principle maybe, but it's at least a rule based on a principle that says how to apply this or that law, right? It's a conflict principle. When two other laws might apply, this one does, right? Are there other conflicts principles in the CISG that are relevant? Can you pass over here?
Based on the scholarly writing, it's not just Article 1 that's considered to be a conflict of law principle. It's actually Chapter 1 of the CISG is considered to be a conflict of law.
Right? Like Article 3, for example.
The whole chapter.
You're doing an interpretation of the party's obligations in the contract, and either this law or that law will apply, depending on whether it's a predominantly sales contract, right? There's an argument that because of that, we have new ones, that the exclusion of those conflicts of laws principles is excluding or derogating from Chapter 1 of the CISG, right? In order to do that, you have to be able to demonstrate that the CISG isn't applicable just as a substantive law in the CISG itself, but actually as something that you need to go into and choose in that manner, right? The CISG is either operating as a choice of law instrument and determining what rules will apply based on choice of law principles, or is a substantive rule of international sales law that applies autonomously and automatically and not subject to the application of private international law rules. Does that make sense? And we have to know the difference in order to make that argument. It's a tough one. I see you shaking your head, right? So Article 11A, for example, the convention applies to contracts for the sale of goods between parties of whose place of business are in different states when the states are contracting states, right? That's a matter of fact. That's not necessarily, there's no application of any kind of choice of law rules that need to occur in order to do that. We're not looking to party intent. We're not looking to the subject of the contract. We're not looking to anything. Is there a sale of goods? Here there absolutely is, right? We've got goods moving, right? We don't know if they're predominantly or not a sale of goods, but we know there is a sale of goods in this contract. There's party from two contracting states. This is the law that applies, right? That would mean that this is a substantive rule of international sales law that applies just as its own self, right? If it's a conflict rule and you can turn it into a conflict rule, a conflict principle, rather than that substantive rule of law, then you can say this is something where the parties, it's the method through which we choose this law, and that conflict principle is excluded in the party's contract. So we don't look to the CISG, so it would never apply because we've excluded the possibility of its application, which is tough. But Zlatan wrote a really hard to read article, actually, not because it's poorly written, but because it's super complicated, specifically about this thing. There's an article by Zlatan Meskic, who's at Prince Sultan University, wrote an article like this. I've read it. I had a lot of trouble understanding it because it's a super, super complicated argument, but it's in there and you can read it and figure out how to do that. I think it's an interesting argument.
I have a question. So I'm really hung up on the or part of this article. So it says when the states are contracting states or when the rules of private international law. So in 11B, does that mean they're not contracting states?
Yes.
Yes.
One of them is not. Yeah.
Okay. So
And it's interesting in the convention, it says when there's the conflicts of laws rules being applied, right? So maybe the application of excluding the conflicts of laws principles really only applies to 11B. See? But we need it to apply also to 11A in order for that to work, the exclusionary rule to work. Does that make sense? That's the kind of research that we're going to need to figure out how to do. When you're doing your memo, it's unfortunate that you do your memo and then you really learn how this all works because you have to learn it for the next few months. But go back to your memo. You've done a lot of work in research, but sometimes as you're doing that work, you're kind of forget about it. You're too busy trying to write the dang thing as opposed to doing that reading again. Go back and look at how you developed your arguments for these things. Check those sources again as you learn, because you're going to understand them a lot better. There's going to be basic principles that you don't really get at the beginning, and you start to understand them as you go. But you've got this big document that has all your sources in it. Rely on it. It's going to be super helpful later on as you continue your reading. You're going to get the mic over here.
Can you please further explain about the application of actually not applying the 3-2?
What do you mean?
So basically for the claimant, it's a really good point because we're able to classify what are the goods and what are the service. However, for the respondent, that math, let's say, it basically doesn't work.
Yeah. Do we want to try our outline to get through this? Okay, we'll deal with these now. Because we've been focusing almost entirely on exclusion.
Yeah,
Didn't spend as
exactly.
much time on that before. But yeah, we'll switch over and we'll talk about that first section. A little bit rushed, but while trying to write out a roadmap for y'all so we can see how we build roadmaps. Is that all right? Okay, great. Okay.
Do you want to start?
Sure. So your roadmaps. Now we're building out your oral arguments. Have y'all drafted your roadmaps yet? Has anyone tried this? Yes? Who wants to tell me their roadmap? Don't be scared. I saw you immediately look away after you first nodded. Yeah, here. Do you have your roadmap in front of you, or do you have it? All right, let's do it. Oh, you already have one. Yeah, great.
by roadmap, do you mean what structure I addressed each point?
Yes. Yes.
With the first argument you want to try to make.
3-2, definitely. That services are more preponderant to goods.
Okay. And what do you say? Do you have a roadmap as you would give in an oral argument?
So the first point would be to contradict claimant's assertion that the chart should be considered to calculate the goods over services.
Are you going to contradict claimant?
Or disregard that?
Because you're going to go first as a respondent.
Because
So how are you going to contradict them? I'm just
Tell your story first.
yeah.
That's-
So you want to say your story first, and it will be really silly, as the claimant might say, and tribunal will be like, but you don't know what they're gonna say, So it's a tricky thing to do, and not the best way to put yourself in a position where you're talking and presuming something. What the claimant can then do is like, we were not planning to say that, I would maybe do that just for the point of it, and I'm like, you know what? No, that's not what I'm going to say. I'm going to focus on this.
Yeah, and you'll find more arbitrating, by the way. We're going to kind of act as different arbitrators
Yeah.
and test y'all with questions that other people, not us, we wouldn't ask that question. But, so let's hold off on doing the roadmaps that we have prepared and focus on how to write your roadmap, right? So your respondent, and to start, what's your basic structure, your overarching basic structure? How do we decide what that is? What's our approach?
So,
what's that?
Just a second. Now we agreed to have a standard.
What's the basic approach? What's the very first start? How do you know what your outline should start with?
I look at my two submissions. The
procedural
order.
Sorry.
Forgot the name.
Yes. The procedural order, that's what you need to answer, right? The tribunal has given you express questions. You should answer those questions. That's where your roadmap starts, right? So one, what does procedural order say? What does the procedural order say are the issues on the applicable law on the CISG? Just shout it out. There you go.
Yeah, is the CISG applicable to the agreement? And
right there.
Yeah.
What is our answer? We're a respondent. We're making an argument. What do we say to answer that question?
The CISG is not applicable.
The CISG is not applicable to the PSA, right? That would probably universally be the opening roadmap section, right? Second one. What's the second issue?
If so, have the parties validly excluded its application?
And what's our answer to that as respondent?
We have validly excluded it.
The parties have validly excluded the CISG, right? That's how we start. So when you come into the argument and your time starts, my name is Robbie Chimino. I represent the respondent, Ren Power or whatever, which I feel dumb saying out loud. Like in my head, I hear it and I don't want to say it out loud. It sounds like a dog's name or something. I don't know. Ren Power, and I will be addressing the applicable law issues. My co-counsel, Eva Gergich, will be addressing the procedural issues. We are here today because respondent is big and cool and handsome, and we should win. My argument will be in two parts. First, that the CISG is not applicable to the agreement. And second, if it is applicable, we validly excluded its application. Turning now to my first submission, right? That's how your roadmap works. And that clarity is super important. If you walk in and you start talking about standards or start talking about other things, they won't even know what universe you're in. You've got to tell them where you're going to go, right? And like Professor Fleckner, he's going to go and write it down.
So what I was wondering as well for my submissions is that firstly I was going to say the CISG is not applicable by virtue of 3.2. So instead of saying the 3.2 part, do I just stick with it's not applicable and it has been excluded? I
think you can. I think, assuming that's the only argument you're going to make, right? Yeah, if for example, you might want to say the CISG does not apply by Article 3.2, the CISG does not apply because it's an auction, and if it does apply, we've excluded, right? You might want to do that, but it depends on how you want to structure it. And you got to test out what works, right?
Can I ask why you're starting with Article 3.2? Yeah, yeah.
We're starting with 3.2 because we were trying to argue that services are more preponderant since it's a turnkey project. So that is, like, from what I know of, I feel like it's a good point for the respondent to throw aside the applicability.
How does the CSG even apply?
Under 3.2? The CISG.
No. How do you get to the application of the CISG?
The choice of law clause.
Which is in
the Purchase and Service Agreement, Article 29. 11A.
11A.
Yeah.
Okay, so it's a 1A that you first to determine if the CSG is at all applicable. and then it tells you exceptions when it's not. Meaning, it can be international sales of goods contract. It can be between the parties that have different business place. In those states are contracting states. However, if that contract for the sales of goods has preponderant part of services, excluded. If that contract for the sales of goods was concluded through auction, CSG does not apply. So that's why we are talking about the exception to the application of the CSG and the scope of it, which is Article 2, 3, 4, 5, and 6, which okay? But we first need to address the Article 1. Is it at all, can the at all CSG be applicable, okay? So what we discussed as a claimant yesterday, we tried to discuss, is it even the sales of, I feel like Respondent has arguments for discussing if it's goods or not, okay? And I do strongly believe that discussing of, is it international sales of goods contract will automatically lead you then to the Article 3. But in my opinion, you should not skip the Article 1, okay? Yes?
So I have a question. So we know that application is like starts from 1 till 10. So and like there is only if one thing
It's
is
not 1 to 10.
1 to like
6.
6, yeah.
Why? Because 7, 8, 9.
Interpretation. Yeah, sorry.
No, it's okay. But just to solidify the knowledge.
Yeah. I like it's good. So like the thing is, respondent should prove only one point is not met, but in those articles, like, and the application is excluded. So what point is the like the
So if you can prove that the contract does not fall within the scope of Article 1.1, you already won. So basically, look, it works a little bit, but just messing with me. So basically what you want to say, and even if this will like, it's not an even if, but like moreover, it meets all of these other requirements why the CSG would be excluded, but discussing the exceptions to the scope without defining does it meet the scope, it's a little bit, you rush through it. And also you have to understand not every arbitrator will be well versed with the CSG. I mean, they're a little bit more aware of the CSG than on arbitration and things like that. But you need to make sure that at the end, they're so persuaded by your argument. And if you jump into the discussion without leading them to it, you can lose on valuable, persuasiveness and points that you want to make. So
right, and this is about precision, right? So if you see in Article 3, it says the convention does not apply to contracts in which the preponderant part of the obligations are those who service supplies and labor, right? But by this time, we're in the sale of goods contract. When you look at Article 1, it just says there is a sale of goods. We definitely have a sale of goods, right? That's not a problem. Or someone's buying goods. That's not a problem at all. Then this is an exclusionary provision that if it does apply, it actually is excluded from its application because of the goods aren't the preponderant part, right? So, or the preponderant part actually just labor and services. So it's a technical point, but it matters for being precise and persuasive. So the reason why she's saying under Article 3.2 may not be the best way to start is they're going to say, well, we need to talk about Article 1.1a, but you can be clear and brief in doing that, because what you don't want to do is say, members of the tribunal, the CISG applies to this contract under Article 1.1a because we have a supply of goods and the parties are in different places of business. However, it's been excluded from its application because the preponderant part of the contract is not a sale of goods, right? You want to avoid saying it does apply, it doesn't apply. So you can do it briefly, right? After application of Article 1.1a has 2 requirements. There is a sale of goods, however, it is excluded for this reason, or something like that, right? You got to find a way to be both precise and brief and persuasive. Does that make sense? So it may be better to say the CISG does not apply. And then when you get to your part 1 in your sub-argument, you say the CISG is excluded from its application under Article 3.2, right? That's different than it does not apply at all because we don't have a sale of goods. Its application is excluded under Article 3.2. See what I'm saying? Okay.
Okay. After Article 132, do you want to address anything else? Auctions, okay. Do we have a good argument here for the auction?
Why an auctions next? Yeah, why auctions after 3.2? Isn't there one other component? We're still in Article 1.1a land, right? There's another component here that we argue doesn't match. The different contracting states, right? We're saying the place of business, right? The place of business isn't there. And it's not, there's two reasons why I think that would go before auction. One is auction's a tough argument, right? It's not your strongest. You want to put your strongest arguments first. But more importantly, the structure of the law is consistent with your argument, right? If you're talking about 1.1a and there are three components and you're saying that two of them aren't met, then you can say, here's how they're not met, right?
Yeah, and that's why I think you need to start with an Article 1. Because why would you discuss the exception to the application of it, and then you need to discuss the internationality factor missing, you know? So what you have to be is really innovative with the language, but precise. So I would say, you know, the requirements under Article 1.1a were not met, and there are several of them. Internationality factor, and the factor that this is, yes, a sales of goods contract, but it's not entirely sales of goods, which would lead me to further, you know, elaborate why. So you give an indication, but you're like, let me first discuss this internationality and why under Article 1.1a it cannot be applied. Because can you scroll to the 1.1? Those are cumulative requirements. You know that word? Cumulative, meaning all three have to be met. And if they're not, it does not apply, okay? So you can have a sales of goods contract, but if they're in domestic, it does not apply, okay? You can have a good contract, but they're in two different contracting states, two different states, but they're not contracting states. The CSG does not apply, okay? So if one of the elements is not met, the CSG does not apply, and it doesn't fall within the scope of Article 1.1a.
And secondarily, and relatedly to the reason why this order matters, is Article 2, the exclusions in Article 2 don't come into play until Article 1 is satisfied, right? It doesn't say so expressly, but of course that's the case, because what they're saying is if you have an international sale of goods contract that was concluded by auction, then the CISG is excluded from its application, right? And all of the other versions of this. For example, ships, vessels, hovercraft, or aircraft are all goods, right? They would be goods, but here, even if it is a sale of goods of multiple ships and aircraft or whatever, CISG doesn't apply to it, even though the other things are satisfied. So you want to, for the purposes of a clear application of the law and for persuasiveness, because you have to understand those two things go hand in hand. Doing the law properly and in the proper order is the way to be persuasive. If you're going back and forth, you're going to confuse the tribunal because, again, we're like a scared little cat. You don't want to spook us. You got to keep us organized and clear so we know what we're talking about. And you can say that the elements of Article 1.1a have not been met, including that while there is a sale of goods, the preponderant part is this. And second, that the parties are not in different contracting states because claimant's place of business for the purpose of this contract is Equatoriana. And then third, and least powerfully, members of the tribunal, this is an auction.
And you want to put that at the end, and only if you have time to discuss it. So it means that's why you have to be really good with the time management. Because if you're already at 0.6 and you're still, you know, finalizing answering the questions to your two main strongest argument, you don't want to now start discussing auction because it's going to maybe lead to a question. And instead of maybe doing in a minute, you have to do like 2-3 minutes more because it gets complicated. And what does it happen? It eats up on your time for issue D. And you, to get a good points on the time management, you should provide the amount of time to both issues, okay? So you have to be really careful. Have this argument auction if everything goes smoothly and you just want to be like, moreover, you have it ready if you're asked the question, okay? But it's not going to be your priority. And by the way, what Robbie correctly pointed, you know, this convention does not apply to sales by auction. it's not our strongest argument for the respondent because it was not done as sale, was not done by the auction. Okay, auction was used to determine who will be the two contract partners that we will probably enter into a contract to. Okay, it was not usually. Do you know how auction works? Let's pretend. You know.
We just have 2 or 3 minutes.
Oh, sorry.
Yeah.
No, and we don't not going to lose time. But the point was when you read the scenario, it says based reverse tender, reverse offer, like completely. They have chosen two potential business partners with whom they have initiated the negotiations, and claimant won because they had the best deal ever. So it was not done the sales by auction. Yeah.
So could it be just possible to address the 2 points, which is Article 1 and then Article 3, and then proceed with the exclusion?
You can if you'd like, but you have to be prepared for the auction answer. Yeah, go ahead. And for right now, I don't want you to skip those things. We need to get some practice in addressing all the problems.
Because in fact, yesterday you have mentioned that I think we should try to avoid, as also for the claimant to answer at any circumstance about the reverse auction.
You don't want to introduce it because
Yeah.
you're being responsive, right? You want so what we're doing here is the outline for the respondent, who is the affirmative pleader. They come first, right? And you get the advantage because you get to tell your story, and then they've got to respond to your story. If you do this really well, structure it really clearly, script out how you're going to do it really well, you can even hit auction, right? And then you can make them have to respond to it. You can skip it if you think it's just really weak and terrible, which it might be, right? You don't want to look uncredible to the tribunal. But if you got a decent argument and you want to give it a shot, then I think you should try to include it because you've got more hills for them to climb. You want them to have to respond to those stuff, right?
So just for this pre-moot, you'd say it's better to address all three, because I think even if we don't address one, the tribunal is going to be like, where is
They're going to be asking about that auction. Yeah, you need to be prepared for that kind of argument. So you should really be focusing on, because you've got a lot to do in that first section. You should really focus on your structure. That's what really matters. So you build this roadmap out. It needs to be consistent with the law, organized in a way that's legally valid and recognized, and brief and accurate, right? The precision really matters. So where I say this is an auction, that's not what you should say, right? It is the PSA is excluded by auction.
And why do you need more time for this one, 3.2, for example? Because you need to lead us to the record. You need to show us, what was in a contract. You need to show us that witness statement where they have those numbers, So you need more time to properly explain this to be persuasive. So only if you're asked, I would discuss the auction, and we will probably ask you during this pre-moot because it's a more educational experience. But for tactic purposes, I will not introduce this. Why? Because I know that the claimant has a little bit better arguments to attack us on it. And if I introduce it and then claimant goes on like, there's no way this is, sales by auction, what does it mean? Even if we sounded strong on, 1 and 2, on 3, and that will be the last thing they will address. So the impression is that it's not as strong. So, but that's more on a long run. Unless some of you come here and convince me this is the sales by auction, and I'm like, oh my God. So I'm open to that.
Yeah. Okay, so we're wrapping up. It's 10:45. The next session's at 11. So you can get a quick coffee break and get some water. I know we haven't finished doing that outline, but I hope these principles will help you understand how to draft your roadmap. Come and talk to us more about how to do that, any other questions you might have about it. But apply the law as it's properly structured, and be sure to be brief and precise when doing your roadmap, and let us know what you're going to be doing. There are also additional sub-roadmaps you can do. Don't be annoying, right? Don't say, I'll have 2 points, and then I'll do it in 3 points, and then I'll do it in 2 points, and then I'll do it in 2 points, right? There's limits, but you want to be able to give us structure when you get to the Article 3.2, because that's not a simple argument either, right? So be able to have those structures as you go along and guide the tribunal. Okay, great. Take a break. Come back here when you're done.